Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to learn the evidential value of an injured witness. That means the witness who was present on the spot, who was also assaulted by the opposite party. Yes, definitely the evidence of the injured will be placed on high reliance. It has got greater evidential value, as stated in the case of Balu, Sudan, Khalda. Balu, Sudan, Khalda and others versus the State of Maharashtra in criminal appeal number 1910 by 2010, and the judgment was delivered on. Actually, the appeal was dismissed on 29/3/2023 by two judges bench, Honorable Justice Sudhanshu Dhuria and J.B. Bhartiwala. Right? So, the bench stated that the evidence of the injured person, it has got greater value. Of course, unless compelling circumstances they exist. Indeed, his presence cannot be discarded and doubted unless there are material contradictions in his deposition. This is what is held and we accept it also. In our younger days, maybe in the year 1979 or 78, there was one famous sub-inspector by name B. Murali. So an incident of murder took place in Pellur village. ఆ సందర్భంగా విట్నెస్ వచ్చి, సార్ నేను చూస్తున్నాను అయినా సరే ఏం చేయలేకపోయాను, నన్ను కొట్టపోతే నేను చిలా తప్పుకున్నాను, చిన్న గీత పడింది అంటే, ఒరే గీత చాలా ఇంపార్టెంట్, ఇట్ షోస్ యువర్ ప్రజెన్స్ ఎట్ ది స్పాట్. ద ఇంజరీ మీన్స్ డెఫినెట్లీ షీ గాట్ ఎవిడెన్స్ వాల్యూ అని చెప్పి ఇమ్మీడియట్గా అతన్ని హాస్పిటల్కి పంపించారు. ఆ కాలంలో గవర్నమెంట్ హాస్పిటల్ మన కోర్టు పక్కన ఉండేది. అప్పుడు యాక్చువల్గా ప్రాక్టికల్ ఎక్స్పీరియన్స్ బెస్ట్ ఎక్స్పీరియన్స్ అండి. అప్పుడు నాకు అర్థమైంది, ఇంజ్యూర్డ్ పర్సన్ ఎవిడెన్స్ ఇంత విలువ ఉంటుందా. కానీ యాజ్ అ డిఫెన్స్ సర్టిఫికేట్ మనమంతా ఏం చేస్తుంటాం, ఇంజ్యూర్డ్ పర్సన్ అనగానే సార్ హీఈస్ ఇంట్రెస్టెడ్ విట్నెస్, హీ హిమ్సెల్ఫ్ కాజ్డ్ ద ఇంజరీ, హీ హాస్ గాట్ మెడికల్ ఎయిడ్, వాడు కావాలని చేసేది చెప్తా ఉంటాం. అఫ్కోర్స్ ఫర్ ద డిఫెన్స్ పర్పస్. ఈ పాయింట్లు దీంట్లో ఈ కేసులో వస్తాయి కాబట్టి జాగ్రత్తగా వినండి. రైట్. సో కమింగ్ టు ద ఫ్యాక్ట్స్ ఆఫ్ ద కేస్. On 1/4/2001 at about 11:15 p.m. while PW1, he was chit-chatting along with the deceased. His name is Abbas Baig. So he was there. Those were the days. There, 2001. They were sitting in front of certain area and they were chit-chatting with each other. At that time, the Sudan, Khalda and others, they came as a gory mob and attacked and assaulted the deceased Abbas Baig with swords and sickles. Swords and sickles, they are very dangerous weapons. At that time, he shouted loudly, this PW1, but he was also injured. He suffered bleeding injury on his head. So he has given the FIR. He is the author of the FIR. So what more evidence is necessary? He himself was present at the spot. He himself was injured. He himself deposed before the court, where in spite of the keen contest or keen cross-examination, vociferous cross-examination, he withstood the test of classification. Therefore, the sentence was given by the lower court. Of course, as usual, he went to the High Court, but the High Court also dismissed the appeal. Ultimately, as the life sentence has been confirmed, they approached the Supreme Court. Right? So here, the advocate on behalf of the appellants, he argued that the presence of PW1 is itself doubtful and no corroboration can be given for the presence of the witness, because nowadays the people are able to manage the government hospital authorities and they can get the certificates. So because he is injured person, because he was placed as a PW1, all these statements have come. These are all cooked up statements which you cannot believe. But please remember, the medical certificate and the accident report, where In the wound certificate, it will be clearly written, wounds or injuries found on the person of a body of so-and-so, who was said to have been injured at so-and-so place on so-and-so date at so-and-so time. Very clearly they are written. It can't be cooked up, because just within hours, 3 hours, within 3 hours they have given the FIR. So the evidence plays a high reliable piece, remains a high piece of evidence. Now the points. Please remember, actually the defense lawyer wanted to take advantage of section 4 to section 300 of the APC. You may know, culpable homicide is not murder. So if it is done without premeditation, if it is done in a sudden fight, that is grave and sudden provocation, if it is done without offender's undue advantage, if it is done during the fight with the person who is killed, but this cannot be called because the witness was there. There he was chit-chatting with the deceased person. The accuser came as a gory mob. So the Supreme Court highlighted the following 3 points, basing on which the appeal was dismissed. Number 1, the evidence as a whole, it has shown the ring of truth. The evidence, when you took all the facts, when you took all the material evidence, yes, it forms the ring of truth. Truth యొక్క ring correct అయింది. Second, even for long hours of cross-examination, he withstood the test of cross-examination. Witness అంత గొప్పవాడు. వీళ్ళు ఎన్ని రకరకాలుగా మెలికలు పెట్టినా సరే ఈ మెటీరియల్ ఫ్యాక్ట్స్ పోలేదు. థర్డ్ పాయింట్, ఇట్ ఈస్ highly undesirable, or the witness cannot be expected to have photographic memory of the incident. They tend to do some mistakes. చెప్పే దాంట్లో పర్ఫెక్ట్గా చెప్పాలంటే అయ్యే పని కాదు. సో whether there are material contradictions or not, this you have to do. If there are not material contradictions, definitely they can be allowed. So ultimately the appeal was dismissed. Kabatti is a very important case where an injured witness is there, where there are injuries to him, where he says that he was present at this spot, definite conviction. So you can cite this case law. With this, I am concluding. Thank you very much.